The billing alert arrived at 2:17 a.m. on a Tuesday, flagging an invoice discrepancy that would unravel everything I thought I knew about trust. I'm Gregory Montgomery, 42, legal technologist at our Native American law firm in Albuquerque. 20 years of practice taught me that anomalies in legal billing systems rarely appear without cause. This one made my coffee grow cold as I stared at the screen. The alert showed a $47,000 retainer payment from the Pueblo Water Rights Coalition, a client I'd never heard of. According to our case management system, I'd been their primary counsel for 8 months. The problem was simple. I had no memory of this client, this case, or this money. I pulled the file from our digital archive. Every document bore my electronic signature. Every court filing listed me as counsel of record. The client intake forms showed my handwriting, or something that looked remarkably close to it. The timestamps showed regular activity, motions filed, discovery requests submitted, settlement negotiations conducted, all work I'd never performed. I cross-referenced the billing entries with my calendar. During the periods when I was supposedly representing the coalition, I'd been buried in the Navajo Nation Gaming Compact negotiations. 16-hour days. No time for additional clients. The retainer funds had been deposited into our firm's trust account, then transferred to our operating account in increments that matched our standard fee structure. Everything appeared legitimate except for one detail. I'd never seen a penny of those fees. I checked the client contact information. The phone number led to a disconnected line. The mailing address belonged to a vacant lot in Santa Fe. The email bounced back as undeliverable. Someone had created a phantom client, generated 8 months of billable work in my name, and collected nearly $50,000 in fees. The digital trail was sophisticated, too sophisticated for a simple billing error. I ran a broader search through our case management system, filtering for any files bearing my name that I didn't recognize. 3 more phantom clients appeared: Desert Wind Development, Four Corners Mining Consortium, and Rio Grande Agricultural Trust. Combined retainers totaling $127,000. All fake, all bearing my signature, all generating fees I'd never received. The office was empty at this hour, fluorescent lights humming over rows of empty desks. I printed the suspicious files, my hands steady despite the implications. Someone with administrative access to our systems had been running a sophisticated fraud operation using my identity as cover. The question wasn't just who had done this. The question was how long they'd been doing it, and what else they'd been hiding. I locked the printed files in my desk drawer and cleared my browser history. Tomorrow I would begin investigating my own firm, my own colleagues, my own partners. But tonight I sat in the darkness and wondered how many other phantom clients were generating fees in other attorneys' names. The building's security system logged my departure at 3:41 a.m. As I walked to my car, I realized that whoever was behind this would soon discover that someone had been digging through the files. They would know it was me. The phantom clients had been operating for 14 months before I discovered them. I spent the next 3 days reconstructing the timeline, working late shifts to avoid drawing attention from my colleagues at the firm. Micah Osborne had joined our partnership 18 months ago as knowledge manager, bringing impressive credentials from a large Denver firm. His role involved maintaining our case management systems, overseeing document retention protocols, and managing client intake procedures. The timing aligned perfectly with when the fraudulent accounts began appearing. I'd trusted Micah completely. We'd worked together on several complex tribal land disputes, and his attention to detail had impressed everyone in the office. He'd even helped me streamline my own case management workflows, gaining administrative access to my files in the process. The sophistication of the fraud became clearer as I dug deeper. Micah had created realistic client profiles using publicly available business registrations and tribal entity databases. He generated authentic-looking retainer agreements using our firm's standard templates. Most cleverly, he'd structured the billing to mirror my actual work patterns, higher activity during court filing deadlines, reduced hours during vacation periods. Our firm's trust account procedures required dual authorization for transfers above $10,000, but Micah had circumvented this by breaking larger retainers into smaller installments, each falling just below the threshold. The incremental transfers appeared routine, especially when they matched established fee schedules. I discovered his method by accident while reviewing our quarterly financial reports. The phantom client's payment patterns were too perfect. They never disputed bills, never requested detailed invoices, never asked for case updates. Real clients always had questions. On Thursday morning, I approached Isadora Whitfield, our senior paralegal and the only person I trusted completely. She'd been with the firm for 12 years and knew our systems better than anyone. "I need you to run a discreet audit on our client database," I told her, closing my office door. "Look for accounts with minimal contact history and perfect payment records." Isadora's expression sharpened. "What kind of audit?" "The kind that stays between us until we know what we're dealing with." She spent 2 hours in our records room, emerging with a manila folder thick with printouts. "Gregory, we have a problem. I found 7 additional phantom accounts across 3 different attorneys' caseloads. Total fraudulent billings exceed $200,000. The scope was staggering. Micah hadn't just targeted me, he'd been systematically exploiting multiple attorneys' identities to create an entire network of fake clients. The other victims were Isadora Chen and Robert Martinez, both senior associates who frequently worked extended hours and might not immediately notice additional cases appearing in their files. "How did he access their signatures for the retainer agreements?" I asked. "Digital signature software," Isadora replied. "He had administrative privileges to generate electronic signatures for document processing. Completely legitimate access, completely illegitimate use." That afternoon, I confronted them methodically. Micah had used his position to exploit every aspect of our firm's trust. He'd accessed our client database to identify potential targets. He'd used his knowledge of our billing systems to structure fraudulent transactions. He'd leveraged his administrative privileges to forge documents and manipulate records. The most damaging discovery came when I reviewed our malpractice insurance claims. 2 phantom clients had filed complaints alleging inadequate representation, triggering insurance investigations that could have destroyed the careers of innocent attorneys. Micah had been playing both sides, creating fake clients and then using them to generate insurance fraud. I spent Friday evening documenting everything, building a comprehensive case file that would satisfy both our state bar and law enforcement. The pyre was overwhelming. Forged signatures, fabricated client communications, manipulated trust account records, and systematic identity theft. But as I prepared to present my findings to the partners, I realized Micah had been more careful than I'd initially understood. He'd structured the fraud to implicate the victim attorneys as potential co-conspirators. If the scheme were discovered, we would appear to be the primary beneficiaries. The phantom clients had been paying their bills directly to accounts that bore our names. The forged signatures were sophisticated enough to pass casual inspection. The billing patterns matched our legitimate work so closely that proving innocence would require extensive investigation. Micah had built the perfect frame, and I was about to walk into it. On Monday morning, I arrived early to find Micah already at his desk, reviewing case files with his usual professional demeanor. He looked up as I passed, offering the same friendly nod he'd given me every day for 18 months. "Morning, Gregory. How was your weekend?" "Productive," I replied, continuing to my office. I had 48 hours to decide how to proceed. Confronting Micah directly would give him time to destroy or manipulate records further. Going to the partners without absolute proof could backfire if he'd prepared additional safeguards. But waiting longer meant more phantom clients, more fraudulent billing, and more potential damage to innocent attorneys' careers. That evening, I made my choice. I called Isadora and asked her to meet me at the office after hours. "We're going to the partners tomorrow morning," I told her. "All of it. Every phantom client, every forged signature, every fraudulent transaction. Are you sure we have enough?" "We have enough to prove the fraud exists." whether we can prove who's responsible. I paused, looking at the stack of files on my desk. That's going to depend on how well Micah covered his tracks. As I locked the NR office safe, I realized that tomorrow would determine not just Micah's fate, but potentially the survival of our entire firm. The phantom clients represented more than financial fraud. They represented a systematic betrayal of everything our practice stood for. They paid out of pocket to fix a client error I caused. The irony wasn't lost on me. In trying to protect our firm from Micah's fraud, I was about to expose us to the very scrutiny that could destroy us. Tuesday morning arrived with the weight of inevitability. Isadora and I entered the conference room at 8 sharp, carrying 3 bankers' boxes of. The senior partners, Micah Blackwood, Isadora Crane, and Micah Thornfield, sat across from us with expressions ranging from concern to skepticism. "This better be substantial," Blackwood said, eyeing the boxes. "You've called an emergency meeting without explanation." I placed the first file on the table. "We've discovered systematic client fraud within our case management system. Phantom clients, forged signatures, and fraudulent billing spanning 18 months. The silence stretched for 30 seconds. Crane leaned, studying the documents. "How much are we talking about?" "Conservative estimate? $400,000, possibly more." Thornfield's face went pale. "400,000? That's enough to trigger federal investigation." "It gets worse," Isadora said, opening the second box. "The fraud appears designed to implicate specific attorneys through forged signatures and manipulated billing records." I watched their faces as we laid out the phantom client files, the billing discrepancies, the forged signatures that matched our handwriting samples too closely to be coincidental. "Who has access to modify these records?" Blackwood asked. "Limited administrative access," I replied. "Partners, senior associates, and our knowledge manager." The room fell silent again. Everyone understood the implication. "Micah Osborne has been our knowledge manager for 18 months, Crane said quietly. "He has complete access to our case management system." "We need to confront him immediately," Thornfield said, reaching for his phone. "Wait." I held up my hand. "There's more. The fraud includes client trust account manipulation. If we're wrong about this, we're accusing a colleague of felony embezzlement." Blackwood studied for another 10 minutes before speaking. "The patterns are too sophisticated for random error. This is deliberate fraud." He looked up at me. "How do you want to proceed?" "Controlled confrontation. Record everything. Have our IT specialist monitor his system access in real time." An hour later, we called Micah into the conference room. He entered with his usual confident smile, carrying a legal pad and coffee mug. "Morning meeting?" he asked, taking a seat across from the partners. "Micah," Blackwood began, "we've discovered irregularities in our client billing system. Phantom clients with forged documentation." Micah's expression didn't change. "That's concerning. How can I help investigate?" I placed the first phantom client file in front of him. "This client doesn't exist. The signature is forged. The billing entries were created using your administrative access." For the first time, Micah's composure cracked slightly. His eyes flicked to the file, then back to my face. "I'm not sure what you're implying." "We're not implying anything," Isadora said. "We're stating facts. You created phantom clients, forged signatures, and manipulated billing records to steal from client trust accounts." Micah sat back in his chair, studying our faces. The silence stretched for nearly a minute before he spoke. "You can't prove I did anything." "Actually, we can," I replied, opening my laptop. "Digital timestamps show the phantom clients were created during off hours when only you had building access. The forged signatures match handwriting samples from your personnel file. And the trust account transfers were authorized using your administrative credentials." Micah's professional mask finally slipped completely. "You have no idea what you're dealing with." "Enlighten us," Crane said coldly. "This firm was hemorrhaging money. Client complaints, missed deadlines, billing errors. I fixed problems that would have destroyed us." "By stealing $400,000? Thornfield's voice rose. by creating revenue streams that kept us solvent while you focused on pro bono work that pays nothing. The admission hung in the air like a physical presence. Micah had just confessed to systematic fraud in front of 3 witnesses. The phantom clients generated legitimate-looking income, he continued. The forged signatures protected the firm from client complaints about billing errors. I was solving problems. You were committing felonies, Blackwood said. I was protecting this firm from bankruptcy, I leaned. What about the attorneys whose signatures you forged? You were setting us up to take the blame. Micah shrugged. Collateral damage. If the fraud was discovered, better to sacrifice a few associates than lose the entire firm. The casual cruelty of his statement silenced the room. This wasn't desperation or misguided loyalty. This was calculated betrayal. We're calling the police, Crane announced. And the state bar, Thornfield added. And our malpractice carrier, Blackwood finished. Micah stood slowly, straightening his tie. You'll regret this. The phantom clients generated real revenue. Without that income, this firm won't survive 6 months. We'll take our chances, I said. After Micah left the building under security escort, we spent the rest of the day documenting everything for law enforcement. The state bar opened an investigation within hours. Our malpractice carrier demanded a complete audit. By Thursday, the white-collar legal fraud response group had assigned Treasury Investigation Director Samuel Nash to the case. Nash arrived with 2 forensic accountants and a digital crime specialist. This is sophisticated fraud, Nash told us during his initial briefing. The phantom client structure suggests knowledge of legal billing practices and trust account regulations. The investigation consumed 3 weeks. Nash's team reconstructed every fraudulent transaction, traced the diverted funds, and documented the forged signatures. They found additional we'd missed, manipulated court filing dates, altered discovery deadlines, and fabricated client communications. Total fraud amount is $640,000, Nash reported. Osborne used the phantom clients to cover legitimate billing errors, then expanded the scheme to generate personal income. The criminal charges came first: felony embezzlement, wire fraud, and identity theft. Micah was arrested at his apartment on a Tuesday morning, still wearing the same confident expression he'd worn in our conference room. The state bar proceedings followed. Professional misconduct, client trust violations, and fraud. The hearing lasted 2 days. Micah's attorney argued diminished capacity due to financial stress, but the WAS was overwhelming. Disbarment, the hearing officer announced, effective immediately. The civil lawsuits began within days. Clients whose signatures had been forged demanded damages. The phantom clients' families emerged, claiming they'd been defrauded by our firm's billing practices. These are Micah's accomplices, Nash explained. He created fake identities, then recruited people to play the roles when complaints arose. The firm's insurance covered most of the financial damage, but our reputation suffered. 3 major clients terminated their retainers. 2 associates left for other firms. But we survived. The partners implemented new oversight procedures. All billing required dual authorization. Trust account access was restricted to partners only. And every case file was audited monthly. 6 months later, Micah pled guilty to federal fraud charges. 18 months in federal prison, full restitution, and permanent disbarment. I testified at his sentencing hearing. The judge asked if I had anything to say about the impact of his crimes. He didn't just steal money, I told the court. He stole trust. Client trust, colleague trust, and professional trust. That damage extends far beyond financial loss. Micah looked at me from the defendant's table. No anger, no remorse. Just the same calculating expression he'd worn while creating phantom clients. The judge sentenced him to the maximum term. 12 months after Micah Osborne's sentencing, I stood in my new office overlooking the Rio Grande. The view stretched across the valley, past the cottonwoods to the Sandia Mountains beyond. I'd left the firm 6 months earlier, not from shame or anger, but from opportunity. 3 former clients had approached me about starting an independent practice focused on tribal sovereignty cases. Montgomery Legal Services occupied the 3rd floor of a renovated adobe building in Old Town. 2 associates, 1 paralegal, and a case management system that logged every keystroke. Trust but verify had become my operating principle. The phone rang at 2:15 p.m. Isadora Chen from the New Mexico State Bar. Gregory, we have a situation. A small firm in Las Cruces discovered billing irregularities. The managing partner wants to hire someone with experience in internal fraud investigations. I'd handled 4 similar cases since leaving the firm. Word traveled fast in legal circles. Attorneys who'd survived betrayal were valuable consultants for firms facing their own crises. What's the scope, I asked. Missing client funds, altered time entries, and suspicious trust account transfers. Sound familiar? It did. The patterns were always similar. Someone with access, someone trusted, someone who understood the system well enough to exploit it. I'll drive down tomorrow. The Las Cruces firm occupied a converted Victorian house near the courthouse. The managing partner, a woman in her 50s, met me in the lobby. We discovered the discrepancies during our annual audit, she explained. Our bookkeeper noticed client payments that didn't match our billing records. I spent 3 days reviewing their files. The scheme was simpler than Micah's, but equally devastating. A junior associate had been creating false billing entries, then pocketing client payments that exceeded the inflated amounts. How much? The managing partner asked. $47,000 over 18 months. Her face went pale. We trusted him completely. That's how it works, I said. Trust is the weapon. The investigation followed familiar patterns. Digital forensics, client interviews, and careful documentation. The associate confessed within a week, hoping for leniency. But confession didn't repair the damage. 3 clients filed malpractice suits. The firm's insurance premiums doubled, and the associate faced criminal charges and disbarment. I helped them implement new safeguards, segregated trust accounts, dual authorization requirements, and monthly reconciliation procedures. The same systems we'd adopted after Micah's betrayal. Will we survive this? The managing partner asked. If you're transparent with clients and committed to reform, yes, but it takes time. I drove back to Albuquerque thinking about patterns. Legal betrayal followed predictable paths. Access plus opportunity plus rationalization equaled fraud. The variables were scope and duration, not methodology. My phone buzzed with a text from Nash. Another case in Phoenix. Interested? I was. Each investigation taught me something new about human nature and professional vulnerability. And each successful resolution helped restore faith in legal institutions. Back in my office, I updated my consulting materials. I run firm trust repair workshops post-litigation, helping attorneys rebuild client confidence and implement fraud prevention systems. The work was rewarding in ways I hadn't expected, not just financially, but professionally. I was helping preserve the integrity of legal practice, one firm at a time. The sun was setting behind the mountains when I finished my case notes. The Rio Grande reflected the orange light, flowing steadily toward the Gulf of Mexico. Micah Osborne was 6 months into his federal sentence. The firm had recovered financially and rebuilt its client base. The phantom clients had been exposed and prosecuted. Justice had been served, but more importantly, the system had adapted. Stronger oversight, better controls, and increased awareness of internal threats. I locked my office and walked to the parking garage. Tomorrow would bring new cases, new challenges, and new opportunities to protect the profession I'd chosen 30 years ago. The betrayal that had nearly destroyed my career had instead redirected it towards something more meaningful. Prevention rather than prosecution. Education rather than litigation. It was finally over, and the silence felt earned.